On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
All right. We've got a really good topic of discussion this morning, and I don't have to tell you, we have so many land use conflicts that are present, be it urban, residential, commercial, but they also happen in rural areas as well. And, when you think of nuisance, I guess, the first question you have to look at is what would be considered an ag nuisance?
Well, it depends. That's a good way to start out with a lot of clarity this morning. But a nuisance is an invasion of somebody else's interest in the way they use and enjoy their property. It's not an interference with possession or ownership of the land, but the way that you use it. So basically, an easy way to think of this is I can do whatever I want on my property, on my private property, so long as it doesn't interfere with your right, if you're my neighbor, to do whatever you want to do on your property. So if we think of it in that context, I can't do anything that would unreasonably interfere with your use and enjoyment of your property. You can't do anything that would unreasonably interfere with my use and enjoyment of my own property.
And so we're talking, or potentially examples would be, say, wind farms or large-scale ag operations, things like that, or some that would consider that an ag nuisance?
Well, we get into it with that. That can be. We'll get into the issue of aesthetic injury in just a bit. So it could be an eyesore. And some will view wind farms as an eyesore. They'll view solar farms as an eyesore. Certain transmission lines that create aesthetic-type injury. But in agriculture, historically, what we've dealt with are odors. Odors from livestock, and the placement of facilities is a key issue as to whether it's a nuisance or not. Now, a pen of pigs in central Kansas, for example, or in Iowa someplace may not be a nuisance, but you place a pen of pigs at 5th and Broadway in New York City, and I guarantee you that's going to be a nuisance. So location is an issue. And that's really what nuisance law is all about. I mean, it doesn't really have anything to do with negligence in terms of how you are operating your farming business. And this confuses people a lot because they may think, well, I'm operating my farm with all of the permits that I was required to have. I got all my permits at the state level that are required. I've got permits at the federal level to run, for example, a confinement livestock facility. I am using best husbandry practices. I'm doing everything the way that I'm supposed to be doing. You can still be sued successfully on a nuisance theory. Nuisance and negligence are not the same thing, and that is a very confusing point to a lot of people. And so if you are operating properly, that doesn't mean you're in the clear from a nuisance standpoint, because I go back to what I said earlier. Nuisance, it's couched in terms of unreasonably interfering with somebody else's use and enjoyment of their property. So I could be doing everything correctly and still interfering unreasonably with my neighbor's use and enjoyment of their property. And I think that's probably the toughest thing for people to understand when it comes to nuisance law.
And for the courts, do they try to balance, economic value in all this, and especially to those who are involved or in that area of whatever that use is in question? Do they take a look at that?
They do, and actually, probably 25 years ago, we had a significant Kansas case, or Kansas matter, let me put it that way, on that particular issue, and it was we've seen these issues crop up across the country. I may have a packing plant. I may have some type of industrial facility that produces an odor. There's some type of byproduct that's produced that is offensive, and they get sued on a nuisance theory, and it gets to the court, and the court says, okay, if I shut this plant down, then there's going to be 50 jobs that are impacted or 100 jobs that are impacted. And so the cost of stopping the nuisance may outweigh the so-called nuisance itself. And so the courts do weigh, in terms of the balance of the economic value to society of the uses that are in question. How valuable to society is that use, and what is the interference with nearby property? And so we've seen these cases where if that complaint of use adds jobs and income to the local economy, then the value to society of continuing the alleged nuisance may outweigh the negative impact that it causes. And courts do take a look at that.
So what if there is someone who moves into an area, a new owner, whatever the case may be, and they make a complaint, but yet that what they're complaining about was already in existence? That's an area that is interesting in the aspect of how do the courts look at that?
Yeah, well, that could be a potential defense, and that's going to depend on a state's right to farm law, and every state has a right to farm law that is designed to protect existing ag operations by giving farmers that meet the requirements of the defense of the statute a defense in nuisance suits. One of those ways that those statutes can be crafted is a so-called coming to the nuisance defense, and that is, in your scenario there, if I'm operating my farm prior to somebody moving in nearby that complains about what's happening on my property and complains that I'm creating a nuisance for them, I may be able to assert the statutory defense of, well, you came to the nuisance. There wasn't a problem here until you came. I'm not the nuisance, so you can't sue me. And there are requirements that have to be satisfied when you're asserting that type of defense under most of the state statutes. One is a pretty common one. You were there at least a year before somebody complained of the nuisance. Somebody moved in and complained of the nuisance. And what we're concerned about in these situations are changed circumstances. So it's kind of like in a zoning situation. I'm operating, say, some type of industrial or commercial plant, and then the surroundings change around me, and now I become ostracized because I'm creating problems for neighbors. Well, I was there first. Everybody else moved to me. Why should I be sued? That's kind of the theory. And there was actually just an absolutely fascinating case. I still, to this day, use this in my ag law courses to get the point across. It came out of Arizona many years ago, over a half century ago now. It's hard to believe to me that it's been that long. But this is a case where there was a big cattle feedlot that was northwest of Phoenix. Way out, probably 35, 40 miles out from downtown Phoenix. Well, if you've been to Phoenix in recent years, you get, Glendale, I think is the name of the town where the football Cardinals play. And you keep going to the west and then the north and the west and the north. And what's happened over the years is the development kept getting closer and closer to this cattle feedlot. And this was back in the 50s and 60s and 70s, and the development was pushing out that way. Well, the developer realized they could no longer sell homes as easily as they were in the past because they were getting close to an odor and flies and so forth. And so they sued the existing cattle feedlot that had been there for a long time, and keep in mind was way out from any type of development. They sued them on a nuisance theory, and the court came up with a really, I think, tremendous remedy in this situation. They said, yeah, they are a nuisance. But the developer that was claiming that the feedlot was a nuisance, the court said, okay, they're a nuisance. You win on that point. Why don't you pay their cost to move somewhere else? Now, that's pretty interesting when you think of that. You complained about it. You moved out there. You paid their cost to go somewhere else. And so that's how the court settled that problem.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us and throwing up the discussion, when is an agricultural activity a nuisance? And you can find that on the Ag Law and Taxation blog. He posted this from just this past Thursday. So, Roger, let's say the court determines that a nuisance does exist. What's the next steps then that take place?
Well, the courts actually have a great deal of latitude in fashioning a remedy that they think is fair to the parties involved. And we've seen this in a lot of cases over the years. In fact, there were a number of cases on the livestock side of things with respect to odor issues in Iowa back in the 70s and the 80s, and in fact in northwest Missouri. It was kind of a hot flash point for ag nuisance issues in the 60s and 70s, kind of in that area between St. Joe and Cameron along Highway 36, kind of north and south of there, and then as you go north of Cameron and then off to the east a bit. To this day, you can still see signs out there that talk about animal, livestock odor issues, and it's really been a hotbed. And then you get up into Iowa that have a lot of those issues historically. Well, the courts came up with some pretty interesting ways to solve these disputes, and courts aren't locked into one particular result or not. It may be monetary damages, but it may be a permanent injunction. In other words, you're permanently shut down, or it may be a temporary injunction. And I've seen some say, well, yeah, we've got an issue with respect to surface spread hog manure, and the courts will say, well, spread it during a certain time of the year. Maybe I know of one case where they determined that the neighbor would routinely take a 2 to 3 week vacation and be gone from their property during the summertime. And so they said, well, just spread your manure at that time, or don't spread it on this field that's next to their house. Spread it elsewhere. Or you may see a remedy where if you're going to surface spread manure, then knife it in the same day that you spread it. Get it into the ground to minimize the odor. So the courts will take in all this type of evidence, and then they have a great deal of latitude to fashion a remedy that kind of fits the circumstances. So that's one nice thing, I guess we could say nice about nuisance law, is that the courts do have that freedom to come up with that remedy like they did in that Arizona case over 50 years ago, and say, all right, yeah, you're a nuisance, but the complaining party, you've got to pay them to relocate somewhere else. So they're balancing the cost, they're balancing the impact on the local economy, they're balancing the costs on the locality of having the nuisance there, as well as the cost of getting rid of it. So that's a pretty unique aspect of the remedy situation with respect to ag nuisances.
So let's say, you've heard the word or heard the phrase, something is aesthetically pleasing. But there's been a case, this involves, I guess, solar panels, that the complainant problem, I guess this case looks at aesthetics. How does that look, or how does that was handled as far as that particular case is concerned?
Yeah, and we're going to see more of these cases, Greg, particularly with respect to solar, but we've seen them with the wind energy companies and the footprint, the visual footprint that so-called wind farms put on the viewshed. This is why we don't have wind turbines, and we've been through this issue in the past in Kansas. We don't have them in the Flint Hills because of the concern about what happens on the viewshed and the blinky lights at night disturbing the pitch blackness of the Flint Hills. And so those are what we would call aesthetic type injuries. It's not an odor situation. It's more of an unsightliness type issue, and it makes me feel bad when I look at it. So it's aesthetic. Is that enough to make out a claim for a nuisance related damage type claim? And the general answer is no. Well, it's kind of a maybe. We've had a Vermont case in 2017 involving solar panels, and a couple of energy companies got sued. And the solar arrays, they were claimed to have constituted a private nuisance by negatively affecting the surrounding area's rural aesthetic and causing local property values to go down. And that's, the property value issue is there too with respect to wind turbines. And the trial court said no, and the Supreme Court in Vermont also said no, that's not an issue. Private nuisance actions based on aesthetic injury only are barred, and that's the way it's been in Texas. There have been some prominent Texas cases involving wind farms, and generally aesthetic injury is not enough. Psychological damage is not enough on these things, but there are some exceptions that are out there. There's a Nebraska case that's out there where the court in Nebraska said, yeah, aesthetic injury just by itself is not enough to make out a claim for nuisance. But if you couple that with, and I go back to what I started with, a substantial interference with use and enjoyment of the property, then you might have a claim that is compensable somewhere. So aesthetic injury alone, no, you're going to have to show that it's interfering unreasonably with your use and enjoyment of your property, and that's going to take more than just aesthetic damages.
So let's say the tenant who may have had a nuisance, or I guess maybe gone to court because of a nuisance, doesn't own the land. So how is the landlord looked in all this if a tenant has a case against them concerning nuisance?
Yeah, that's a real good question, because generally we think that, a landlord's not responsible for the deficiencies of their tenant. The tenant's the one that's in possession of the property, and they're the one that's responsible for any type of tort-type issue that they might create. Well, this is another one of these that we have to be careful of, and I remind tenants and landlords of this. Particularly, there was a prominent Iowa case on this a few years ago, and you had the situation where a tenant was farming land for the landlord and handling a hog facility, and of course, as part of that, you spread manure, and that's why land in certain parts of Iowa comes at a pretty high premium when it comes on the market, because farmers like to get a 40 or an 80 to spread hog manure on. And that's what he was doing. He was surface spreading hog manure. Well, you've got the landlord's property. If you picture in your mind landlord's property, and then adjacent to that is the complaining party's property, and then adjacent to that is the property owned by the landlord, again, where the tenant was surface spreading hog manure. So you've got this guy that's right in the middle of two properties, right between two properties, that farm fields that the landlord owns, one of which where the tenant was surface spreading hog manure 90 feet from his back door. Well, he complains to the tenant. The tenant didn't do anything. So he goes to the landlord and he complains over and over to the landlord for 4 years, saying, look, your tenant is spreading this manure 90 feet from my door. Get him to stop or terminate that lease. The landlord just blew him off, didn't do anything. Well, he finally sued after putting up with this for 4 years, and the court said, yeah, the general rule is, landlord, you're not liable for your tenant's deficiencies here, but if you know that your tenant is creating a nuisance, unreasonably interfering with the use and enjoyment of somebody else's property, you are also responsible along with the tenant, and you have the obligation to get the tenant to change their behavior or terminate the lease. So there's an exception to the general rule that a landlord is generally not responsible for what their tenant does. But if you know they're creating a nuisance and you don't do anything about it, you can also be liable as the landlord.
You have mentioned a couple times about potential defenses. What other potential defenses are there in the case of nuisance?
Well, your big one is right to farm. Other ones that can come up are based on state law, so you got to be familiar with how your particular state treats these types of activities. Most common is nuisance related, so your ag operation's only going to be protected if you've been in existence for a specified period of time, and that's typically a year. And other ones, like we have in Kansas, might be related to zoning. You might have county zoning, you might not have county zoning. That's on an optional basis. And ag may be exempted from zoning ordinances. So the major legal issue that we run up against in Kansas on this type of situation is whether an ag use is an ag use, or is that activity a commercial activity. And generally, ag is going to be defined pretty broadly for that. So you just have to, if we've got people listening in Nebraska is different than the way this issue is treated in Kansas. It's different than Missouri. Nuisance law is very state specific, but your general exemptions are either going to be whether you're exempt from zoning, whether you have been there a certain period of time to use a coming to the nuisance defense. Those are going to be the big ones.
So in conclusion in all this, as we wrap up the program, if there are situations like this, what's the best advice or best things that you can tell farmers and ranchers out there who might run into this situation?
Communicate well with your neighbors, be friends with your neighbors, and then use common sense in where you locate things on your property, particularly livestock facilities. Keep them, don't put them onto a border. Use common sense in spreading manure. Don't get close to a neighbor if you don't have to. Use reasonable practices. And again, I come back to getting along with your neighbors. That can go a long way. We get into that issue with respect to fences, too. Communicating well with your neighbors, making sure that you have good relationships with your neighbors is actually a pretty good common sense step to keep you out of legal troubles down the road.
All right. Roger, hey, I appreciate it as always. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.